On November 4th, 1950, a convention was signed that was to become a cornerstone of peace in Europe, setting out a number of fundamental rights that we continue to rely on today. It was the European Convention of Human Rights. The convention and its court were established as a response to the atrocities committed during World War II, with the intention of protecting human rights and promoting democracy in Europe. But what is the European Court of Human Rights, and why is it so important for Ireland? Welcome to the podcast series, The European Court of Human Rights, an Irish perspective. In this first episode, we explore the history of the court and Ireland's key role in its development. Ireland was one of a small number of countries which was involved in the drafting of the European Convention of Human Rights and the setting up of the corresponding court in the immediate post-war period. Initially, the court got off to a slow start, and its judges sat on a part-time basis. However, the court picked up speed in the 1980s and 1990s with significant landmark judgments, and it underwent major change in the late 1990s with an expansion of the number of countries involved after the fall of the Berlin Wall and the ending of the war in the Balkans. The court now has 46 member countries, ranging from Iceland to Malta and as far east as Azerbaijan. Each judge on the court is elected in respect of one of those countries and sits on a full-time basis. The European Court of Human Rights is a human rights-based court in Strasbourg, which gives judgments on the human rights set out in the Convention. It is considered one of the most important human rights courts in the world. Miss Justice Unani Rafferty, Judge of the European Court of Human Rights.
The thing about the European Court of Human Rights is to realise that it's all about human rights. So in contrast to other systems, like, for example, the Court of Justice in the European Union system, which is in a different location, it's in Luxembourg, it was primarily concerned with matters other than human rights. It was primarily concerned originally with free movement of goods, free movements of people, free movement of services and so on. It was essentially, if you like, to encourage movement and commercial transactions in Europe. But the thing about the European Court of Human Rights, which is based in Strasbourg, is that it's fundamentally about protecting human rights. And that's its sole focus, but it's obviously a very big brief. So to give an idea of some of the rights that are protected in it, the ones that are before the court on a really daily basis: right to life, right to a fair hearing, right to respect for private and family life, freedom of expression, freedom of thought, conscience and religion. There's also, importantly, a prohibition on torture or inhuman and degrading treatment. There is a prohibition on forced labour, and there is a prohibition on arbitrary and unlawful detention. Also, in 2003, they introduced a protocol, Protocol 13, abolishing the death penalty.
We might take some of these things for granted now.
Niamh Howlin, Associate Professor at the UCD Sutherland School of Law.
Most people have a very good awareness that they have rights, that they have fundamental rights, constitutional rights, or human rights. But a lot of this was quite new 75 years ago. And it took some time for people, governments and courts to fully comprehend what those rights meant. And it's really been through the jurisprudence of the court, through the cases that come before the court, that those rights have been fleshed out over the last 75 years.
And you read about the courage of people who are trying to defend human rights in some of these countries, and they're really putting life and liberty at risk. It's really important for them and their families to know that there's a court that will say, well, this happened, and we have the details of it. Here's what we say about it. That country violated their rights. There are young people protesting in countries, and they're just like our own children. They're out on the streets wearing the same clothes, waving their mobile phones with the lights on, but they're not waving them at a concert. They're waving it to try and get democracy. A lot of them are doing it, at the age of 19, 20, 21, knowing the risks. And I find that very humbling. And for me, if I can be part of a court that bears witness for those people, then I'm happy to do that. And it feels like it's doing something. It's not enough, but they're saying it's worth doing. And so that's good enough for me. If they're coming to us, and they do keep coming to us, there are 60,000 applications pending. The citizens of these countries keep coming to the court and knocking on the door and say, please tell the world that my rights have been violated.
What drove the founding countries, Ireland among them, to establish this European defence of human rights?
This story takes us right back to the aftermath of the Second World War. Europe had been ravaged by the conflict, and the people and the governments of Europe wanted to ensure that nothing like this would ever happen again. A congress was held in The Hague in May 1948, and it was attended by 1,000 delegates from 20 different countries. And under the chairmanship of Winston Churchill, the Congress enthusiastically backed the first steps towards European cooperation. Then in Brussels, in January 1949, it was agreed that there would be a new body, and it would be called the Council of Europe. In May 1949, a few months later, 10 countries signed the treaty establishing the Council at St James's Palace in London, and they chose Strasbourg as the headquarters for this new organisation.
I think there are two strands to the drive for a supranational definition of and defence of human rights.
Ewan O'Halpin, Professor Emeritus of Contemporary Irish History at Trinity College Dublin.
One is obviously the appalling immediate experience of most of Europe during the Second World War. So on the one hand, you have a drive for, if you like, universal human rights and so on. The other, you also have a more pragmatic, a long-term set of considerations to do with the security of Western Europe. Because there's no question that the Council of Europe initially was established in response to what was perceived as the huge threat of communism under the Soviet Union, a geopolitical threat, but also it was seen as, if you like, almost a moral threat, and certainly as a threat to what the Irish delegation, and they weren't the only people there who said it, the Christian values of Europe. So this dimension of universality itself is linked into geopolitics in a way nowadays would seem quite anomalous. But it's very important to realise the way the debate was structured was largely not simply about the absolute, unarguable right of individuals to live their lives freely and in a rules-bound system, but also the argument was that they can't do that if communism is allowed to prosper, if the Soviet Union is allowed to take over the rest of the mainland of Europe. I think the development of the Council of Europe and of the Court of Human Rights can't be seen in isolation from experience in the interwar period with the League of Nations. The League of Nations is generally now in school books and so on derided as being ineffective because it failed to prevent the rise of the dictators and aggression. But the League did a lot of work in the framework of considerations of human rights as well as of state rights. Many conventions were signed relating to the protection of children, relating to the protection of females, all sorts of areas. But what it lacked was any enforcement authority.
The European Convention on Human Rights was a treaty or a document that set out all these fundamental rights and freedoms, so personal rights, political rights, and so on. But what was different about the convention was that this was the first treaty to actually build in an enforcement mechanism. So this wasn't just declaring rights. This was going further, and this was going to make sure that those rights would be upheld by the states that were signing up to it. So the convention was the first treaty to establish what we would call a supranational organ to ensure that the states that signed up to the convention actually fulfilled their undertakings.
The value of having a court as distinct from simply a set of principles and conventions was that at some point and at some level, states could be called to account at a higher level. Now, the court had very limited powers. It couldn't detain. You can't lock up a state. You can't lock up a government or whatever. But it could apply enormous moral pressure and the recognition by national courts of the, in a sense, the supreme moral and even judicial authority of these conventions and treaties meant that in the legal area, which is where rights ultimately are protected and vindicated, it was through the Council and through the Convention on Human Rights, jurisdiction has emerged, which has proved extremely robust.
Ireland was one of the founding members of the Council of Europe in 1949. In the late 1940s, if you think about the context, Ireland was still a fairly new state, and it was keen to have a presence on the international stage. This new Council of Europe was an opportunity for Ireland to take a role in building the new post-war Europe.
1948-49, there was a series of seismic shocks in Ireland's foreign relations. Ireland was already isolated in that it hadn't been invited to join the United Nations. That was in a sense, the price of Irish neutrality in the Second World War. And secondly, that it was going to leave the British Commonwealth. And by leaving the Commonwealth, Ireland was leaving another international club, if you like. So now Ireland had very few international bodies where real world issues were being discussed, which it was a member. So the Council of Europe looked like being, in a sense, a successor to the League of Nations, as a place where small countries as well as large countries could stand up and be counted on an equal basis and be heard.
But this was a really good opportunity for the Irish state to assert itself as an independent sovereign nation and take its seat at the international table. There was a little bit of wariness as well. It wasn't all enthusiasm. The Republic of Ireland Act 1948 had only recently been passed, and Ireland had only quite recently left the Commonwealth. So the idea of Irish sovereignty was a sort of fragile thing. The Irish didn't want to agree to anything that was going to jeopardise national sovereignty. I think De Valera was probably more interested in functional cooperation between sovereign states on economic issues. But Sean MacBride took over from De Valera as Minister for Foreign Affairs in 1948. And Sean MacBride had a different approach and a different outlook. He was a barrister and he believed very strongly in the international protection of human rights. So MacBride was involved in the drafting of the convention and made a really significant contribution to that. In particular, Sean MacBride strongly argued that there should be power for individuals to bring cases before the Court of Human Rights. And this was something that was really significant and quite groundbreaking at the time.
Ireland played an important role in the establishment of the convention. It doesn't mean, as we sometimes think, that Ireland was a more saintly place. States are states, and the recognition by states that there should be an authority, in a sense, above them in relation to how those states conduct their own business is a fundamental principle. One of the problems with agreeing with a set of principles is that might turn out they apply to you as well as to colonial power in terms of how it treats separatists or whatever. Every country is uncomfortable when it, in turn, is called to account. But that's why, if you like, supranational jurisprudence and supranational legal authority is so important in the world.
Because it's an international agreement, because Ireland had agreed to be bound by the convention, there were some cases in which Ireland was a defendant, and obviously if they were decided, Ireland had to adjust its laws to come into compliance with what had been determined by the court. So it had a significant impact on both Irish case law, and therefore Irish society.
Chief Justice of Ireland, Donal O'Donnell.
It's a legitimate question to say, well, aren't effectively these rights protected by the Irish Constitution, and isn't it better that they would be protected in the specific context of Irish law? And you might also say there's a stronger remedy under the Constitution. There are three reasons, I think. If you take the first bit, why would we want to be part of an international agreement? Well, part of that is the very origin of the convention. It was an attempt to build a structure of what would be a model of a modern Western liberal democracies that would be resistant against what had occurred in the 1930s. And it was important then that we be part of that because we benefit from it. And you can say that the convention has, together with the European Union, slowed what might otherwise been and perhaps inhibited and stopped a slide into autocracy in a number of European countries. So in a sense, we benefit from that because we benefit from that, the degree of stability that brings in Europe. We also benefit, even though sometimes it can be frustrating in the sense that we have very few cases before the Court of Human Rights. If you look at it from Ireland, people seem to sometimes say, oh, the Court of Human Rights has corrected Ireland. If you look at it from Strasbourg, they would say, where is Ireland? Because we are such a small, tiny component of the case law. But in principle, even if sometimes you might chafe against it, it is a good thing to have another eye on your country, on your society, because it makes you stop and say, well, why does somebody think that? Maybe that's right. So it provides an external overview. So that's the benefit of having Strasbourg and having an international agreement to which Ireland's a party and having the right of individual petition and going to Strasbourg. Ireland has had, I think, quite a significant part to play in the convention from early days. And part of that is due to the history that the Convention and the Council of Europe provided this opportunity for Ireland to participate on the world stage and the European stage. One of the consequences of that was we put a lot of effort into participation and sent what I would regard as the A team. People like Sean McBride, who was Minister for Foreign Affairs. Subsequently, Frank Aitken went and was involved in the negotiations. F.H. Boland, who was probably Ireland's most distinguished diplomat and civil servant and the father of our great poet Ivan Boland, and Cecil Lavery, who was regarded as one of the best barrister of his time and was appointed direct to the Supreme Court, and he was involved at one point in the negotiations. So we really put effort into that, and that continued subsequently in a sense that it was always seen as an important place for Ireland to put its best foot forward.
There has been an Irish connection at different stages. So some very influential Irish judges have sat on the court.
The other influence that Ireland has had is with the Irish cases that have come before the court. A number of cases have been critical in the development of the court's jurisprudence and will be explored in future episodes. One Irish case, the Lawless case, led to the first judgment delivered by the court in 1960, where an individual fought for their rights against a state.
Among the key things that were in the convention, along with the rights, were the fact that the court was established and individuals could petition the court. It's called the individual right of petition. What that actually means is as simple as the fact that a prisoner in a cell could write out an application on an envelope and send it into the court, and his case would be accepted. When I say accepted, it would be accepted for processing. It might be ruled inadmissible. He might be successful. It might end up in the Grand Chamber. Who knows? But the point is, it wasn't just an international court for countries or big bodies to bring each other to court. It was a court for the citizens of those countries.
In the 1940s, when all of this was being drafted and debated, it was still quite unusual in the Irish context for individuals to take cases to court alleging that one of their constitutional rights had been breached. And the jurisprudence around personal rights, so the right to privacy and, family rights and so on, wasn't really fleshed out until a little bit later. It wasn't really until the 1960s that there was this understanding of the Irish Constitution as a source of personal or individual rights. Yeah, the idea that an individual could take a case against a state, whether it's their own state or another state, that was very unusual at the time.
And one of the great strengths of the Council of Europe, Convention on Human Rights, and of the legal institutions created under it, is that it showed that Ireland itself was not simply an island of saints and scholars. The Irish state, too, had its flaws and weaknesses. And that's reflected in some ways in one of the first individual case that reaches the Court of Human Rights, which is actually taken by Sean McBride as a lawyer on behalf of an IRA man, an alleged IRA man, who had been interned by the Irish state in 1957. Ultimately, what was known as the Lawless case resulted in football terms, a score draw. The court recognised the principle that an individual could take his or her case. And I say her case because women are almost entirely missing in the first two generations of the council's existence, whether as representatives, the whole issues of gender rights and so on are matters which come much later, but where again the Convention on Human Rights becomes extremely important. But back to the Lawless case.
And the court held unanimously that his detention was contrary to the terms of Article 5. But the court also unanimously agreed that the Irish government was justified in declaring a public emergency which threatened the life of the nation in order to derogate from the convention. So that was the first individual case. So Lawless really was a landmark, not only in Ireland, but also around Europe as well. Most of the cases that come before the Court of Human Rights are taken by individuals or groups of people or companies or NGOs. But it is also possible for states to take cases. So states can lodge applications against other states. These are called interstate applications. Since 1953, there have been maybe about 30 of these cases. So it's not a huge part of the workload of the court.
And those are cases brought by one state against another. The first of those judgments was Ireland versus the United Kingdom, which concerned the interrogation techniques that were used in Northern Ireland in the early 1970s, between 1971 and 1975. The various interrogation techniques, which included hooding of people, and sometimes the case is known as the hooded men case, that led Ireland as a state to bring a case against the United Kingdom as a state. The court delivered judgment on that in 1978 and found that the men had been subjected to inhuman and degrading treatment. Now, in fact, the court decided that it didn't amount to torture, but they did say that it amounted to inhuman and degrading treatment.
And if you like, the hooded men ultimately have a qualified but very significant victory at Strasbourg, in that the court decides that the treatment was undoubtedly degrading and inhuman. And that was a very significant point, not simply in terms of point scoring by the Irish and by nationalists in the north against British rule in Northern Ireland, but it was also a very clear emphasis that individuals have rights and that communities have rights, which to a degree can be vindicated as the national parliament and national courts are willing to intervene.
You have to firstly understand the impact of the convention in Northern Ireland. There's a whole chapter to be written on that, because the convention had this strong role in Northern Ireland as seen as somehow protective of rights and a place you could appeal to. The Good Friday Agreement then, one of the components of the Good Friday Agreement is in fact 3 agreements, but one of them is the agreement between the UK and the Republic, and one of the components was that the same level of rights protection would be afforded north and south. Now, that brings us back to the last point. It was entirely arguable at that time that Ireland did not need to do anything to afford the same level of rights protection as was being afforded in Northern Ireland by the Human Rights Act, because the Constitution protected essentially the same rights and gave a stronger form of review, because laws could be struck down and declared invalid rather than simply incompatible with the Convention or interpreted to be consistent with the Convention. And there was an argument to say, well, we don't have to do anything to perform our side of that agreement, but it was thought, in a sense, best to not to have to get into that sort of second-year law student jurisprudence. It was better to say, well, the United Kingdom have incorporated the Convention. That is part of the law of Northern Ireland. We can incorporate the Convention in almost exactly the same way. And that's, in fact, a reflection of the importance with which the Convention is viewed within Northern Ireland, within the communities in Northern Ireland, as something to which you can appeal to, something that has made a difference in Northern Ireland. And it's built in that sense, into the Good Friday Agreement.
I'll just say something maybe more broadly about the interstate cases. If you look back at the history of the interstate cases that come before the court, most of them arise out of situations of conflict or crisis. So obviously we've had the Troubles in Northern Ireland giving rise to cases. Turkey's military operations in Cyprus in 1974. We had the armed conflict between Georgia and Russia in 2008. The events in Crimea and eastern Ukraine in 2014, and a conflict between Armenia and Azerbaijan in 2020. So usually the interstate cases are arising out of armed conflict. There are currently interstate cases pending that relate to Russia's war against Ukraine, as well as over 9,000 individual applications which relate to those events in Ukraine and Crimea. So the work of the court is always a reflection of the geopolitical realities of what's happening in Europe at any given time.
Since it was established in 1950, the number of countries participating in the European Convention on Human Rights has expanded significantly.
So originally there were 10 member states in the Council of Europe, and when it came to signing the convention, there were 12 members who signed the convention. The original 12 were Belgium, Denmark, France, Ireland, Italy, Luxembourg, the Netherlands, Norway, Turkey, the United Kingdom, Iceland, and West Germany. And those 12 were joined by a couple more countries in the 50s and 60s, so Austria, Cyprus, Sweden, and so on. The first 15 years, I would say, was fairly slow in terms of growth. Then when Europe's last 2 dictatorships fell, Portugal and Spain joined in the mid-1970s. The fall of the Berlin Wall in 1989, which symbolised the end of the Cold War, triggered a wave of expansion for the Council of Europe. So Hungary joined in 1990, Poland in 1991. For the rest of the 90s, we saw former USSR states joining in great numbers. And then in the 21st century, we saw Armenia, Azerbaijan, Bosnia-Herzegovina, Serbia and Montenegro, and Monaco all joining as well. Now, Article 4 of the Council of Europe Statute says that membership is open to any European country provided they meet specific democratic and human rights standards. On the 16th of March 2022, the Committee of Ministers decided to expel Russia from the Council with immediate effect because of its aggression against Ukraine. So Russia remains outside the Council of Europe.
However, there were cases in the pipeline before the court against Russia from before the date it was expelled, and the court decided to continue dealing with those cases. And so those have been coming through the system, but there will come a point when there are none left because no new cases can come in since the expulsion date.
So up until the 1970s, very few cases were actually making it as far as the European Court of Human Rights. And of those that did, the court was only finding violations of the convention in quite a small number of cases. And I think that's quite different to now. If you look at the workload of the court now, it's a very busy court.
And now there are 46 countries and 700 million citizens. And that's its potential pool of applicants, stretching from Greenland to Azerbaijan, from Iceland to Malta. For each of the 46 countries, there's one judge per country. So Ireland has what I might call quite low visibility within the caseload of the court. Ireland has very, very few cases before the court. At the moment, for example, there are more than 60,000 cases pending before the court. Almost 36% of those involve Turkey. Then there are another 4 countries who account for respectively 13%, 12%, 6% and 4%. So that's Russia, Ukraine, Romania, Greece. And then you have Italy, Poland, Azerbaijan, Moldova and Slovenia. And after that, the remaining 37 countries account for 13%. So you can see that the caseload of the court is divided in a very particular way, and Ireland is a tiny, tiny fraction of the court's workload. I work all the time on non-Irish cases. There are officially 2 languages, English and French, but in the corridors you hear 40 languages. You're hearing all these different languages around you all the time.
Γεια σας, είμαι ο δικαστής που έχω εκλεγεί για λογαριασμό της Ελλάδας στο Ευρωπαϊκό Δικαστήριο Δικαιωμάτων του Ανθρώπου.
Buongiorno, sono il giudice eletto per conto della Repubblica di San Marino.
Здравейте, аз съм българския съдия, избрана в Европейския съд по правата на човека.
Вітаю, я суддя Європейського суду з прав людини, обраний від України.
Bonjour, je suis le juge élu au titre de la Belgique à la Cour européenne des droits de l'homme.
Góðan daginn, ég íslenski dómarinn við Mannréttindadómstóla Evrópu.
You're constantly reminded that this is a huge and ambitious endeavour, and really a miracle that it works at all, I think, so when one considers the differences in language, legal culture, professional backgrounds, all of these things.
You know, in the aftermath of all those horrors, to try and come together and build something really constructive and positive that set out personal rights, you know, try to include mechanisms to make sure that those personal rights wouldn't be trampled upon by a state or by a dictator or by a group. It was a very unique time in European history. There's never really been a moment like that since, I don't think. And I think they did a very good job drafting the convention in a very difficult time, in very difficult circumstances. I think it has stood the test of time. I do think that the idea of human rights has become embedded in society. Everybody knows that they have rights now. Everyone knows that they have human rights. They might not know the nitty-gritty, like the legal content, but everyone knows that they have certain rights. That's a big part of what the Convention and the Court and the Council of Europe have done. It's a gold standard for human rights, democracy and rule of law protection.
The role of the Convention in ensuring the protection of human rights is evident in our daily lives.
President of the European Court of Human Rights, Matthias Guillemot.
Over the 75 years of its existence, it has helped to abolish corporal punishment in schools, to prevent torture and ill treatment in European prisons. It has empowered journalists and whistleblowers to exercise their freedom of expression. It has ensured that homosexuality is not a crime anywhere in Europe. These are just a few practical examples of how the Convention protects our rights, the effective rights of more than 700 million people in Europe. The Court's role has always been and continues to be establishing truth, giving a voice to victims, and ensuring accountability. But, as we have just celebrated 75 years of the European Convention, the most pressing concern for me now is concern for the Convention and the Court's future. Today, Europe again faces geopolitical tensions and war. These pressures are made worse by disinformation, authoritarian tendencies, erosion of trust in public institutions, and increasing threats to judicial independence and the rule of law. Some voices today argue that the Convention is not fit to address the evolving challenges that could not be foreseen when it was drawn up. I believe that the contrary is true. The Convention's framework is fit to address today's challenges. Adaptation is in its DNA. The Convention is Europe's unique legal and moral compass. Since it protects us and our shared values and universal rights, we too have a shared responsibility to protect it, to strengthen, not weaken, the Convention and the Court and pass it on to future generations. The Court's judgments are a historical record, a bill of accountability. Human dignity cannot be erased, and truth cannot be silenced.
That is the role of the Convention, in which Ireland has played a fundamental and enduring part. You have been listening to the European Court of Human Rights, an Irish perspective, a curious broadcast production for the European Court of Human Rights. Original music score by Conor Lenihan, narrated by Rory Lonergan. This is part 1 of a 3-part series. In the next episodes, we will examine how the Court and the Convention have impacted on Ireland, and how Ireland, in turn, has impacted on the Convention and the Court. Thank you to our contributors, Justice Una Ní Rafferty, Professor Niamh Howlin, Professor Ewan O'Halpine, Chief Justice of Ireland Donal O'Donnell, and President of the European Court of Human Rights, Matthias Guillaumer. Special thanks to the Department of Foreign Affairs and Trade, our editorial team, which includes Judge Brian Murray of the Supreme Court,